Mr. Deputy Chief Minister, Mr. Finance Minister, Justice Joseph, Mr. Shetty, Ms. Thakkar, ladies and gentlemen, and most especially all of you, my young friends, the lawyers, the guardians of the Constitution hereafter. I thank Justice Joseph for this opportunity to come here on the day after Madras's birthday, which was yesterday, to come back to my Guru Bhumi. I was a junior of Mr. G. Ramaswamy of the Madras High Court, who then later on went on to become Attorney General of India. And Mr. Ramaswamy was also a government pleader here. And in that capacity, in the early DMK government and including the troubled days of 1976 and all that, he's told me many stories of how the Deputy Chief Minister's family also at that point of time suffered, and how the lawyers of those days fought to preserve whatever little liberty that they could in those troubled days. Now, you have heard so much about all the problems in the Constitution, all the various ways in which there are little problems. And part of this problem is the fact that we have possibly the longest constitution in the world. Napoleon said that a constitution has to be short and ambiguous, so that the same thing can mean several things, and you work your way around. However, when we wrote our constitution, we took the framework of the 1935 Government of India Act, and on that imposed the founding fathers' vision of what kind of a new republic that we would build. We, the people of India, gave ourselves a constitution which promised to each of us liberty, equality, and fraternity, and assured the dignity of the individual. That was the goal. Now, we've had 75 years of working the Constitution, and before me, I see people who will work it over the next half century at least. And with all the problems that we have been speaking about all day, the only way that we can solve some of them, work some of them, is, where necessary, to amend the Constitution. It's only where necessary. It is not that you create a problem and then suddenly decide that a constitutional amendment is the solution. Unfortunately, over the last 10 years or so, in an era of majority-heavy governments at the center, what has happened is that the Constitution has become a plaything of the majority. One fine day, one great man can get up and say, "Kuch tufani kiya jaye," or something. Let's do something marvelous. Let's bring a constitutional amendment. We just saw it. We saw it at the end of this session of Parliament, where the Constitution's 130th amendment said that, okay, if you don't get bail within 30 days, you go out of office. The problem is that our Constitution being so large, the Constitution makers realized that you could not have a static document. You cannot say that these are the 10 commandments, that thou shalt do this, and that it will be graven in stone and nobody can change it. No. You also saw that if you made amendment too easy, okay, just let's change it, then it would not remain a constitution. So we decided that if you wanted to change the constitution, you would have to have a majority of the total house. 543, you need 272. But when it came to voting, you needed 2/3 of the people who were present and voting. So if it was a situation where 272 on one side is opposed by 271 on the other side, then the constitutional amendment does not go through. But if there are 272 on one side and there are only 100 people on the other side and another 100 odd people have decided to not even come to parliament, then the measure passes. You see, not every provision of the constitution requires this procedure. There are some provisions of the constitution which have a built-in elasticity. There are provisions on citizenship. There are provisions on the making and unmaking of state boundaries. Parliament can just pass a law. Just in the morning, Justice Chelameshwar spoke of how his home state of Andhra Pradesh, they decided that, look, we'll split it into Andhra Pradesh and Telangana, and that was it. There was not much consultation. So there are several provisions of the Constitution which have elasticity. And one of the elastic stories comes from Tamil Nadu. And it is a great story. The great story is one which has actually enabled me to speak to you today in English. In 1965, the year that I was born, it was the time that 15 years had passed after the Constitution came into effect. And in the Constitution, the provision read that the official language of the Union shall be Hindi in the Devanagari script and that English would continue. But after 15 years, Parliament could take a call if it so desired. There were all these questions which came up in the debates on the Official Languages Act, where Mr. C. N. Annaduraya, Anna to all of you, Anna to many more in India, and unfortunately not known so far much beyond this state. It is to C. N. Annadurai's vision where he opposed the demolition of English, saying that we will not continue with English, and where he insisted that English had to continue, and where English's continuation was supposedly won by one single vote in the drafting. And as a consequence, the Lal Bahadur Shastri government and then later the Indira Gandhi government continued with the usage of English. And look at what happened in the future. By the time that the Narasimha Rao government came in and we had our BPO revolution, the very fact that English had become an Indian language, the very fact that we have now more English speakers than both the USA as well and UK combined, allowed us that great advantage with the English, with the business process outsourcing, legal process outsourcing, the entire framework of the dividend that accompanied our liberalization process. And today, what not many people have realized, and Mr. Ashok Vardhan Shetty also spoke about English and how it was, how it continued. What we do not realize is that we are entering into the era of artificial intelligence, large language models, and LLMs which are more and more trained on English and English data. The very fact that we have people, we have as vast a portion of humanity as the rest of humanity combined, that can program these LLMs, that can utilize these LLMs gives me hope that Anna's revolution or Anna's stand at that point of time will yield us a further dividend. So my point simply is this, that constitutional amendments should not necessarily be at the mercy of one man or of one set of people or of one ideology alone. After all, what is a constitution? A constitution for a country is a contract between citizen and citizen, and between citizen and government, and between governments and government. We, as citizens, have compacted with each other that the rights that the Constitution confers, that we all agree that we will give ourselves these rights, and so long as you enjoy those rights, it is only then that I too get to enjoy those rights. The Constitution is also how governments interact with each other. What is the language? What is the Finance Commission? What is the Election Commission? Everything. It's an operating system for a country. Now, when we come to problems where there is a constitutional provision that may stand in the way. Now, for instance, there are provisions of equality, of opportunity. Yet, what is equality of opportunity? Is it to be a sterile 50% rule where, no, 50% has to be earmarked for one category, and up till 49, you can make your provisions? Is that always to stand in the way? Or are there ways of changing it, or even providing an alternative way of looking at things? If instead of looking at reservations, if we were to look at it as allotments, that each category of people, depending on the social need, were allotted a certain amount of their call on public employment or on public resources. Would that not constitute a separate way of looking at things, or a separate or a different explanation to the nation? Possibly. For each and every of those visions or these changes, the procedure for amendment is reasonably well set out. The question is, do we need safeguards there? Do we need safeguards against majorities which may be transient or which may be more long-lasting, saying that now we are here in a majority and we can rewrite the Constitution, we can make it what it seems. The Supreme Court has put in its own barriers. The Supreme Court has said that yes, you can amend the Constitution by all means, but you will not destroy the basic structure. Now, what does that mean? It only means that if you think of the Constitution like an ancestral house that has been given to you, that you have inherited, you can better it. You may change a wall. You may open out a few windows. But you cannot necessarily load it with so much that the whole structure falls down. Nor can you just bring down the whole edifice and recreate something else. You are bound by the past. You are necessitated to take into account some features which are so basic, including federalism, including secularism, including free and fair elections, that in respect of those things, you cannot make any changes. Excuse me. Now the procedure is one thing. A constitutional morality is another thing. We've heard that phrase being used even to justify the 130th Amendment. But morality is often what we lawyers and some politicians prefer to dispense with. Therefore, it is better that we start working and looking at safeguards. One of the most important safeguards is the safeguard of time. You saw how the 130th constitutional amendment had to be sent to a select committee. And maybe by the time it comes back, the majorities in parliament will change. Maybe it can be passed or maybe it can't be passed. But if parliament in both houses had that same majority which was capable of steamrolling a constitutional amendment, there would be no safeguard of time also. So one proposal that I thought was that no constitutional amendment can be passed except in a different session of parliament. There would be an adequate safeguard in as much as people would have to have time to think about it. If there was to be public backlash, that too could be negotiated. After all, any legislation travels, as somebody said in Hindi, from sadak, that's from the road, to samaj, to society, to ultimately to parliament and the Supreme Court. So sadak, samaj and Supreme Court is now the troika of lawmaking. It is here that when time is given, when time to think is given, and when time to organize is given, that there can be a break, a time for pause, and that which will distinguish a constitutional amendment from ordinary legislation. Also, it may be better that all constitutional amendments, and not merely the amendments which affect the federal structure, should also be ratified by at least 50% of the states. We already have that provision that some constitutional amendments would require state ratification. That should be made a uniform norm. And as far as constitutional amendments are concerned, the justification for those constitutional amendments would necessarily have to be debated with at least a fixed amount of time in Parliament. Otherwise, we have had constitutional amendments also being passed with barely 10 minutes of debate right at the end of it. This is as far as, these are my thoughts for the moment as far as amendment of the Constitution is concerned. There is a smaller subject that I've been asked to speak on, and that is with regard to the territorial integrity of states and especially with regard to the seabed. Territorial integrity of the states, as I've already told you, is totally at the mercy of Parliament. Parliament can change your boundaries. Parliament can create new states. One of the things that the Constitution has left a bit fuzzy is the territorial waters next to the states. For a distance of 12 nautical miles, they are territorial waters. Do they belong to the Union? Do they belong to the state concerned? And beyond the territorial waters are the economic zone which India claims. Now, do they belong to the attendant state? Or what is the extent of state rights over it? 297 of the Constitution says that things of value within territorial waters or continental shelf and resources of the exclusive economic zone west in the Union, that is, the center owns it. But if you read that very carefully, it is things of value within the territorial waters or continental shelf. Do they necessarily have to be under the water or on the seabed? What about rights of fishing? What about rights of maximizing utilization on the territorial waters? In Goa, there is, for instance, casinos are not allowed on land. But in the territorial waters, in the rivers out there or on the sea out there, you have these huge ships on which casinos operate. What are those areas and how are they to be handled? We for the state of Tamil Nadu have had some problems with regard to fishing rights when we have banned the use of trawlers during certain seasons. So far, the courts have upheld them. The courts have had occasion to deal with these questions, but more or less they have skirted the issue. There was a case called Great Eastern, which was with regard to levying of taxes on any action within the territorial waters. Great Eastern Shipping Company ran a chartered vessel which provided services outside the city of Mangalore, and could the state of Karnataka tax it? The Supreme Court got over it by saying, yes, since the agreement was signed in Karnataka, you can tax it. But can you exercise jurisdiction over the territorial waters is an issue which is still at large. So while we take up constitutional amendments and specifically looking at the future, rights within territorial waters, even if they vest in the Union, would have to be fairly shared with the states which are appurtenant. After all, the entire purpose of this exercise is not only to bring about a spirit of cooperative federalism, but essentially to tell the people of India that every one of us is an equal partner in constituting India. Each state is an equal stakeholder and a shareholder. While we may not have come together as confederating states, or to use Professor Mohan Gopal's expression, whether we may have come together as various people under various political entities in a warp and kind of federalism, what we definitely are not is we are not mere subjects, mere supplicants of the center. It is only when the component parts work as they have worked in Tamil Nadu, and specifically I was reading about how Tamil Nadu's economic growth is now among the highest in the country and is the engine for India's future dreams, especially with regard to industrialization. It cannot be that while we are a component, we are treated only as a subject for taxation, only as a subject to churn money towards Delhi and get very little in return. If India as a federation and as a union of component parts is to continue in the era that you all at the back work the constitution of the future, we would have to think hard and look at amendments which would safeguard states' rights. Thank you very much. Thank you for a patient hearing.